Owning real estate in California comes with a hidden risk. Your name and assets could be just a quick search away from a greedy lawyer. Whether you're worried about lawsuits, unwanted attention, or simply protecting your privacy, keeping your investments anonymous isn't as easy as it used to be. I'm Ali Talai, estate planning and asset protection lawyer, author of Estate Planning for Real Estate Investors, and also founder of Talai Law Offices. In this video, I will go over the strategies you can use to stay under the radar and keep your investments private. Stick around until the end to learn the mistake you must avoid if you're trying to stay anonymous when investing. So let's talk about why real estate investors would want anonymity. Obviously, as a real estate investor, you're purchasing properties. When you purchase a property, the ownership of that property is public information. So if you purchase a property under your personal name, anybody could go to the county and find out that you are the owner of that particular property. When you start your investment journey, obviously at the beginning, you don't have a whole lot of investment, so you are very small target, or realistically not a target at all. Nobody wants to sue you at that point. But as your investment and portfolio starts to grow, you start to become a larger target. And when you become a larger target, it means you got to be careful, because there is a greater chance that you're going to have lawsuits filed against you just because the other side knows that you have substantial assets, and there's a greater chance that you'll just pay them something to make the lawsuit go away. So I know a lot of times investors purchase their real estate under the name of an LLC. However, unfortunately in California, if you're a real estate investor and you create an LLC and that's where you sort of stop, and you purchase the property under the name of the LLC, you're correct that your name is not going to reflect under the records of the county. However, in California, LLCs are required to file a document called a Statement of Information. This document gets filed right at the beginning when you create the LLC, and then at least every 2 years after the initial filing. And inside of this document, the Statement of Information, many different information about the LLC you have to disclose, but one of the key spots that you have to provide is you have to provide and indicate who's the manager or the member of the LLC. So if you purchase a property, and let's say you do step one and you do actually prepare an LLC, and you purchase the property under the name of the LLC, you're correct, your name is not going to appear on the public records. However, if now whoever it is that is looking at this LLC goes to the Secretary of State and pulls up the LLC under the Secretary of State and looks at the Statement of Information that was filed, obviously they're going to see your name as the member or manager of the LLC. And this whole anonymity planning or privacy planning is not going to really be around for very long. It's not the best privacy planning that you could put in place. So let's talk about what you can do to provide you with better anonymity planning and privacy planning. One of the things that we do for our clients a lot, we create a land trust. So instead of placing the property directly into the LLC, we place the property into this land trust. Land trusts are practically irrevocable living trust. A revocable living trust is a document that is used for probate, avoiding probate, and incapacity planning. A land trust could avoid probate. However, the reason we use the land trust is not so much to avoid probate. What we're trying to do is to provide you with privacy by using the land trust first. When you use the land trust, we're going to make sure whatever land trust we create, it is named in such a way that does not refer back to you in any shape or form. So if you're purchasing a property, a lot of times we name the land trust the property's address. And so now you own and you take property ownership under the name of the land trust. Land trusts do not have to file any Statement of Information. So if this person finds that you have this particular property and searches the address, the owner will show up as the land trust. As you may know, trusts are not recorded anywhere. The content of them is not recorded anywhere. Nobody really knows who's the owner or who is the creator of the trust. It's really information that you have and the attorney who drafted the document would have. So it would stop whoever it is right there, and it won't allow them to go any further. Inside of a land trust, what you can do, and one of the reasons land trusts are used, in a land trust setting, the beneficiary of the land trust, you can actually name another entity as the beneficiary of the land trust. So usually in a revocable living trust, you create a revocable living trust, and in most cases, individuals name their children as the beneficiary of the trust. So now if something happens and they pass away, the property and assets that were placed inside of that revocable living trust is given to the beneficiaries, to the kids. There's usually a person named in a revocable trust. In a land trust, there is no requirement for you to only name a person. You could actually have an LLC or an entity named as a beneficiary. So in the structure that I'm trying to explain here, we're going to create a land trust. We're going to make sure you transfer the property into the land trust. The land trust will name the LLC that we're going to create for you, or an LLC that you might have, as the beneficiary of that particular property. So then the property goes into the LLC, not directly, indirectly. This will allow us a better privacy and anonymity planning versus directly transferring the property into the LLC. So step 2 now could be that we can start adding another LLC to own our California LLC. And the reason we may want to do something like that is that when you get to file a statement of information, if you are holding and owning the California LLC under your personal name, at that point, when you get to file the statement of information, you may run into the same problem, because it's going to ask you to disclose who the manager is or the member of the LLC. So at that point, we really have 2 options. One is we could incorporate and have maybe a Wyoming LLC as the holding LLC. A lot of times we do that for added asset protection, but at the same time, if we now have another entity that owns the California LLC, we can disclose and indicate that entity there. Wyoming doesn't disclose who the member or manager of the LLC is, so to a certain extent, we could get some anonymity there, or we can use a trust as the owner and member of that particular entity. What I'm really trying to get to is that a lot of times with these plannings, when you start doing land trusts and LLCs, you kind of have to run through the whole plan and figure out, do we get to a place that may expose the ownership of the particular assets and you are going to be disclosed there? So what I'm really trying to get to here is that a lot of times the planning we do, what we want to do is we want to run through the whole planning and figure out, do we get to a place that we are required to disclose who the actual owner of the property is? And in most cases, we're able to set up the estate plan in such a way that the person's personal name will not be there. It could be their trust, it could be their LLC, or other entities that they may own. Another way to own property so that your personal name does not reflect on the ownership of the property is using a trust. And if we want to have a trust in place that will provide us with added asset protection, we could use an irrevocable trust. An irrevocable trust, again, just like the land trust, the content and the agreement of the trust, they are not recorded anywhere. So if you take ownership under a particular irrevocable trust, nobody is going to be able to go anywhere and search something and find out who created the trust. By having an irrevocable trust, you are able to now incorporate additional asset protection planning within your estate plan. An irrevocable trust means the person who created the trust, he or she unilaterally does not have the power to revoke the trust. It does not mean that we cannot have somebody else within the trust and that person having the power to revoke the trust. Irrevocable trust, I know a lot of times people get scared by having an irrevocable trust, but the reality of it is they're not as scary as you might think. Trusts are contracts, and an irrevocable trust can be written in such a way it still allows you many indirect control over the trust, so that truly if there needs to be certain things that would have to be changed and updated, you still will have the power. And if at some point you say, I don't want the trust anymore, there are ways to create irrevocable trust that can actually be revoked and sort of take you back to how the assets was owned and set up right at the beginning. What not to do when you're trying to stay anonymous? Well, first, don't buy the property under your personal name, because the information about who owns the property is public information. Number two, don't purchase the property under a California LLC if that California LLC is going to be owned by you personally, because that California LLC will have to file a statement of information, and if you own that particular LLC just under your name, that information or your information will be reflected on Secretary of State's website. Let's talk about when is it more important to have privacy planning in place. The reality of it is, again, if you just have one property or you don't have a whole lot of assets, you're not concerned about privacy. If you start to now acquire more properties, it becomes more important to have privacy planning in place. If you are a real estate investor and you personally deal with a lot of the tenants in place, it becomes a lot more important to have privacy planning in there. If you have a larger estate and you're worried about having lawsuits filed against you because of the size of your estate, having an anonymity plan in place becomes helpful. Again, having an estate plan that only provides privacy, that is only step number one. I don't want you to think that is enough. I don't want you to stop there. You got to have more advanced planning. We would want to have the LLCs. We would want to have the holding LLCs. We would want to have maybe an irrevocable trust plan and structure built into your estate plan. So anonymity and privacy is important because it makes you a smaller target. If you're a smaller target, there's a less of a chance that you'll be involved in a lawsuit, but that is not where you stop. You got to make sure you have proper estate planning in place. We just dove into how to keep your real estate investment private in California. However, you're probably making a mistake in your estate plan that could cost you everything. In this next video, I will cover top 10 estate planning mistakes that you need to avoid in California. See you over there.